Good evening. I'd like to welcome everyone to the October policy meeting. I'm Jen Ionetti, committee chair, and I will start with asking Ashley Kitten if there's any announcements.
No announcements.
Okay. We are going to start with second readings. Most of these, this is the third month we've looked at these? Yeah. We started working on these in August. So, Ashley?
Ms. Ionetti, do we need to do minutes first?
Oh.
And I actually have a question about that. Weren't we behind on a set of minutes? Am I making that up?
Minutes isn't on here. Oh, there's minutes. Oh, it's after second reading.
Is it? It used to,
Well,
okay.
No, it shouldn't. I mean,
Yeah.
normally.
Normally it's not, okay. In my head, I was like, that's the next thing, but.
But it's actually listed here after. So what do we want to do? We want to just do the minutes real quick? Okay, because we'll probably forget now. Okay, let's do the minutes first. Has the committee had a chance to look at the minutes and we are ready to move them forward to legislative? I'm seeing yes, yes. John?
Yes, but I think these are the minutes from September, right? I don't think in September we did the minutes from August, because I feel like, was that the one where the meeting was really close? Wasn't there some issue with, we were like behind on a set of
Yeah, we
minutes?
can go
right,
back.
right.
Miss Brooke Evans, if you can check to make sure what we did approve. I think you're right. We had 2 meetings within 2 weeks.
Yeah.
Right.
So I would double check those. So if you want to approve these, and then we'll go back and make sure that we have everything approved. I think you're right.
Okay, so we're okay to approve these to legislative, yes. Okay. All right. Now, old business, second readings. This is the third meeting we're working on these, and Ashley's going to get us started.
Okay. I'll make 2 comments on these holistically, and then I'll turn it over to the committee for discussion. I know that we've had some discussion on wordsmithing and what these things look like, and some things surrounding the word handicapped, and that we're still using that word because it's in the PA Human Relations Act. We don't love it. We understand that it's outdated, but that word is still a callback to a lot of other legal language. And the only other thing that I'll make sure that I put out for discussion is the pregnant versus pregnancy-related conditions. I know there was some discussion back and forth about utilizing it in 234, but not utilizing it in 103 and 104. There's no legal reason to or not to. So for consistency purposes, when we bring it to the board for final approval, we're absolutely comfortable with having that. So those are the pregnancy-related conditions in all for consistency, because that is what we believe, that is holistically what we are doing and what we should continue to do. So there's no reason to not have that language in there. So I just wanted to point out those 2 things prior to having any discussion on second reading policies.
Okay. So did everyone follow that? Because it was just inconsistent. So they will all say pregnancy and pregnancy-related conditions. Okay. What else on the second readings? Go ahead, Jenna.
So where did we land on the equal versus equitable? Because it is, as I went through, so that's why I'm bringing it up now, because it'll kind of permeate some of these. I am not going to die on either hill, to be totally honest. I just think we should be consistent. So I kind of still see some of both, so.
We went with equitable. I think that's where we decided, and what the recommendation from administration was to be equitable in all, and we'll make sure that all of those words are the same.
Okay, because I think the 103, our first, second reading says we actually went from equitable to equal in the first line. And there's probably some other places, I just kind of, I'll raise it as a short global issue. I promise I won't raise it on every one. I'll leave it to you guys to find them all.
Absolutely. There was some back and forth. We'll make sure that we do the find.
Okay, cool.
Anything else on the second readings? No, I'm seeing no. Jenna? Nothing? Oh, go ahead.
So I'm just making sure this was a second reading. Yes, okay, so 234, the pregnant and parenting students. In 1.1, it says that nobody will be denied admission to an educational program, activity, and service. I think it should be or service. It's like in the third line for me on my version. In 3.2, on the second line, it talks about, when a student informs a district employee of the student's pregnancy. It doesn't mention parenting. Is that intentional? Because this is pregnancy and parenting, so I didn't know if we want to include parenting or if there was a conscious reason it would only be pregnancy. It says or related conditions, but I think you said that's the catch-all for pregnancy, so.
So the requirements under Title IX, this is really about the documentation and the notification, only speaks to pregnancy.
Okay, that's fair. Yep, I just want to make sure that was intentional. Sounds like it was. I had the same comment on 3.3, but that's probably the same answer. And then in 3.3, for me, it's the fourth line. Again, it talks about equal, and again, we'll, I assume, change that to equitable access to the district's educational program. In some other places, I think I made this comment last time, we added activities and services, so I think we just have to add it to that section as well. And I think that's it for me on second readings.
And no one else has indicated they have anything on the second reading, so we are ready to move on to new business.
Okay, new business, first readings, we have 4. I'll go through holistically, give some notes. I will give the caveat where we are in the process with our AR review. We're working through some things with our solicitor, having those conversations, but we really wanted the first reading to happen because there might be some preferences that might impact the AR. So I would ask tonight that we focus on policy and look at the content in the policy. And then when they either come back for second read next month, or if we keep any of them in first read, we'll have a more up-to-date AR that we can kind of pick apart and fine tune a little bit more. So I just wanted to say that first. So you will see the 4 under first read, and I'll go through what those look like and then turn it over to the committee for question and comment. So we're looking and recommending we're suggesting to repeal 103.1, which right now is listed as educational equity. We have an equity in education policy in 827. The things that we feel like we need to address as a whole are followed in that policy. We would look to review that to ensure to see if there's anything else that we wanted to update and look for. But 103.1 is supposed to really be more in a line with students with special needs. And those things are baked into 104 for students. So because we're looking at this from a Title IX perspective. So in all, 103.1 as it is currently written is covered in other policies and is not legally required to have that. So that's why we're suggesting the repeal. Any comments, thoughts, questions on that suggestion?
No, I mean, I did look at was it 827? And it does appear to me that everything is in there, and that's the more recent policy. We spent a long time working on that, I think a year ago. So I'm comfortable with repealing this one. Yes, yes. Go ahead.
So yeah, I'm comfortable with that. And maybe I missed it. Are we going to still have a policy that's targeted to students with disabilities?
So
it's going to be subsumed in the larger one?
Correct.
Perfect, okay.
Okay.
Okay. So if we're okay with that, next on our list is 202, which is eligibility of non-resident students. The reason this came up for review was related to Act 67 of 2024 and regarding some residency dispute provisions within that policy. Since I can't get my board docs to update, I will probably defer to Dr. Smith on a lot of the questions, but I'll turn it over to you all for questions, comments, review, and then we'll go from there.
Okay, who wants to start? Jenna, you look like you're ready to start.
I'm happy to let someone else start, but I can do some jazz hands while other people are thinking. So I didn't have much here. So on 1.3, it says the board shall require. I think it should just say the board requires. And then in 3.4, which is after the kind of embedded chart, so the district shall verify information presented during the registration by all of, and we changed it from reasonable means to available means, and this may be based on, the new statutory language, but I will say requiring verification by all available means sounds like a high standard to me. So I was actually going to suggest we sort of do a combination of the two that says reasonably available means, because I don't, it's not like we're going to send necessarily private investigators. I mean, when I think of all available, that could be a lot. So unless that's statutory language, I would just, I think we might want to loosen that requirement on the district to be exhausting all means to verify.
Not statutory. I heard a voice in my head when we looked at this, and it may have been Mr. Sirota saying, what's reasonable? Whose definition of reasonable? What does that look like? I have no preference. I don't know if you do.
As Mr. Wallach knows, lawyers like the word reasonable for that very
I love it
reason,
too.
because it does vary with the circumstances. So depending on the situation, verifying this way might be reasonable, this might be unreasonable, but to me, all available means is a very high standard that we're, imposing on the district, and that I don't know is necessarily what we mean.
I don't have a preference either. We can certainly add it back. I do want to just point out in 3.4, Mr. Diazio did make a suggestion that we change shall to may, and that we add to the end in accordance with applicable law.
Well, that would make actually a big difference. If it says may, now I'm fine with available. So, yeah.
Okay, well, that was his recommendation.
Okay, there we go. And let me just see if I had anything else. That's it for that one.
Okay, I have a few things on this one. Does anyone else? No, okay, let me get my. Oh, Jeff, go ahead, go, because I'm getting my notes ready here.
I just had kind of two questions or comments on 1.4. The first part says the board reserves the right to verify claims of residency. I'm wondering if verify is the right word, because as I understand it, there's a possibility of there being a hearing before the board or a designee of the board. So I wonder if it should be like determine or hear or adjudicate. I'm not sure what the right word is, but I wasn't sure if verify is really what we do in that capacity. And then my second, in the same 1.4, and then it says to remove from school attendance a non-resident student. And I'm not 100% sure how expulsion works, whether do we do the removal or how that works? And I just wanted to clarify that to make sure the language was right with practice.
Yeah, so technically, after administration does the investigation and makes a recommendation, and there is an opportunity for a hearing, the parent may choose to take that hearing or not, there would actually be a board agenda item for an expulsion of the student. Yes.
That probably satisfies my second question. First one I still leave out there for discussion.
Go ahead.
Not so much like fine-tuning wording, but just being curious about what would happen next if that were to happen. Like, is there any kind of follow-up or continuity of like care to make sure that that student lands somewhere else, or does it kind of end with us?
Yeah, so the administrative reg, once we finalize that, I know Mr. Diazio has some suggestions for that, would allow the family to appeal that decision, and during the appeal process, the child is permitted to stay in district until that finishes in the Court of Common Pleas. And then let's say they don't appeal or they don't win the appeal, the child is then dropped from our enrollment, or our rolls as we call it, and they are expected to enroll in then the school that they reside in. It would be the responsibility of the school in which they actually reside to make sure that they attend or file truancy against them because they reside in that district.
Are they notified, or I just know of cases where kids don't come to school for a while?
Yeah, I
And that
don't
there's
think
like
there
a-
is. I'm not aware of a process by which we reach out to other districts or other districts reach out to us to say that there is a student. I'm not sure how often this happens, though. I can look and see or talk to my colleagues. I don't know, Ashley, if you know of any. I'm not aware of. Good point, though.
Okay. Do you have another question?
Yeah, I think it happens probably a lot in other districts, and maybe they have some.
Oh, yeah, like other districts might have a process. I understand. So it's first reading, so it's worth looking into.
I wanted to go back to Mr. Wallach's first point, that I think the result is either valid or invalid. So that verified claims, maybe it stays verified, maybe it's just validate. I think that is what you are doing, though. So to answer your question.
Okay, so in bringing up this policy, I looked at some of our neighboring districts, and it reminded me that the districts around us, the few that I looked at, Wissahickon, Lower Merion, Upper Moreland, and Hatboro, Horsham, Cheltenham, they all have a contingency, or I'm going to call it a 12th grader clause. And I didn't, I wanted to hear what the committee has to say, and maybe what Dr. Smith has to say about the situation when we've had an Upper Dublin student, and then at some point around that 12th grade year, the family moves out. So I can tell you, let me see what Lower Merion says. Regularly enrolled children who are seniors and are expected to graduate and whose parents, guardians have moved from the district after the beginning of their senior year shall be permitted to complete the year without payment of tuition, so long as the child was lawfully enrolled in the district at the time of the child's parents / guardians moved from the district. When I see all the districts around us have something about the 12th grade students in this policy, and then we don't have it, I think that we need to discuss that and think about that.
Yeah, Ms. Ionetti, I am familiar with a statement like that from my past school districts. I think the way this policy is written is class 4 would apply to that in the chart here. We may want to, if the board wants to call it out specifically for seniors, this is the section where if your parents move in the years, it's not just limited to only seniors, but if your parents move outside of the district and you want to continue enrollment for the remainder of that school year, you are allowed to remain for that year. So I think ours is a little broader in that it actually applies to students that are not seniors. It could be a first grader or a second grader. The piece that I wonder where the board is at, though, is it does say, certainly class space has to be available, and it does indicate that the parent or guardians pay tuition in monthly installments. So if you wanted to have something else specific to call out seniors, I would suggest it falls somewhere in there. But I do think they're covered here, but you could be more specific.
I mean, I agree with Dr. Smith. I think that's where it would fall. I guess if you marry that with provision 3.3 about tuition relief, relief isn't defined, and the superintendent can work with families on tuition relief and present it to the board for approval. I think in that scenario, although it doesn't expressly say it, a family could say, I'd like relief for this last month. And if Dr. Smith brought that to us for approval, I think we'd have the power to do that. To me, that's a form of relief. I mean, relief's a pretty broad term. So I think that can happen. Whether or not we should say it expressly or not is a different discussion.
I would agree.
Yeah,
Opinions?
I agree. I think it does fall under class 4. I mean, as to the point that Dr. Smith raised about, maybe some other districts' policies don't say this about requiring tuition. I am all for, in that type of situation, having a practice where we let somebody finish their senior year, but I have to say, right, if you have not paid school taxes, for example, for that year, as, somebody representing district taxpayers, it's a little bit of a hard pill for me to swallow to say that they don't have to pay tuition. I mean, that's, everybody else in the district has had to pay taxes. So I am all for having that flexibility, but I do think it's appropriate to have them pay tuition unless there's an approved, what do we call it? Where's that in 3.3? Relief.
Okay. Yeah, I mean, essentially, like, when we're talking about a senior, the reason a 12th grader to me is different is, I mean, we can graduate that student and essentially it's not costing us much because they're just being in classes that we already have. It's unlikely that they're going to tip the scales and we have to hire a new teacher, like for a senior in high school. So it's a little different than the other grades. But if everyone feels like it's covered and we can do that and maybe help somebody, some family that, unfortunately something happens their senior year and the tuition would be a burden, we're able to relieve that, then I think we're okay.
I think that the way this is written actually strikes a really nice balance because you could have someone moving out in September of their senior year, right? And so that is a person who I think should probably pay the tuition because that's a lengthy period of time. Somebody's family moves in April or May, and that's a different situation. And that's where I think this provision, 3.3 allows that flexibility. And so it sort of strikes a nice balance between a lot of different situations. And I think the way it's written right now, I think makes a lot of sense.
Okay, so we will leave it as is. I mean, it's still coming back for a second reading, so there is still more time for discussion. Needed.
Ms. Ionetti, I have a comment or two on this one as
Oh,
well, if that's
sorry.
okay. Unless, are there board members that have other comments? I would like to suggest, and I apologize that we didn't have this in the actual recommendations here on the draft. 3.2, I would like to suggest is removed. I don't believe it's been the practice, even though it is in policy. And I'm not sure how realistic that is for me or my designee to notify you of the acceptance of any non-resident student within 5 days of enrollment. I did share with the board the numbers that we have that qualify as non-resident students. And I do believe 3.7 is something, though, that we could do. And I haven't been here a full year yet, so I'm not sure what time of year this was annually shared with you, but that one does indicate reporting annually on the number of non-resident students, which could be a chart similar to what I have shared with the board, or we could do that in a public meeting, whatever you would prefer. But I would request 3.2 be stricken unless you want me to start sending you emails or announcing at board meetings. We'd have to figure that out.
I'm fine with that. Ready? Okay.
I am too. As long as it's in compliance with the policy, I don't actually know why we need notification each and every time. I think it's just, if we're in the relief category, then obviously we get involved in getting the annual report. I think that's plenty.
Agreed. I was trying to figure out what I would actually do with that information. So I am comfortable with it being removed.
And the only other request that I'd like to make is to 3.5. Without qualifying under this policy and without appropriate advanced permission, I'd like to put the word documented in there, if that's, I think that advanced permission should be on a written document somewhere and not a verbal communication, just so that everything is documented, I guess would be the word, if the board's okay with adding that.
Yes. Okay, I'm seeing yes all around.
Thank you.
Okay, back to first readings, and that brings us to 339, uncompensated leave.
So 339 is another policy that came up in review because of Title IX changes. Really just was a, just in case there is anything in there that would be needed to be addressed because of these changes. We didn't really have anything. So really, we just put it up for review. I didn't really have anything big to point out. Any thoughts, comments, questions on this?
Go ahead, Jenna.
I have a really minor one, but in 3.2, there's an inconsistency. So basically it's saying if, anything in here conflicts, with various different documents, then those other documents control. That's basically what it says. But in the third line, one of the things that's listed is board policy, but then at the end, we use the term board resolution. So it says, if I skip the other terms, right, to the extent any provision of this policy or the accompanying AR conflicts with the provisions of any board policy, then the provisions of that board resolution shall control. So I don't know whether we meant to say policy or resolution, but they don't jive with each other.
Got it.
Okay. Anything else on this one? No? Okay, then that brings us to 803, school calendar.
Okay, 803, updates include language for the legal change to minimum number of days or hours for a school year. We had conversation about this at a separate meeting. The policy is just up for review to make sure that that reflects those legal conversations.
Go ahead, Jenna.
So I don't have any issue with the words in here, but it raised a question for me, which is related to 1.4. So we have the right to alter the school calendar, and we've had to do that from time to time because we notice something after we publish it, okay, fine. But what is our process for notifying the community? Because I think what sometimes happens is people print out the calendar as soon as it's released, and then something changes and they're not necessarily, it's in the legislative briefs, but let's be honest, we know not everybody sits and reads our board legislative briefs. I'm realistic in that regard. So I do think we need to be a little bit more proactive in notifying people when we make those changes because they're planning vacations and then they get surprised that, oh, just kidding, that day off moved to a different day. So.
And it's probably going to be different now because we have new people at new seats. I do know at a minimum at the past, we've put the pop-ups on the website and things like that. So we can definitely talk about what that looks like moving forward. But being that there are new people in new seats, I think that we'll take that back and make sure that that happens more proactively. I think
Just
it's
a
great
recommendation,
point.
maybe at least in the, we get weekly updates from the middle school principal, the high school principal, the elementary school principals, maybe put it in there for, a week or two or something. Just, I know some people have gotten surprised by that in the past.
And we used to have the Google Calendar, but we lost that ability to do that. Remember, you could just have the school calendar like layered on your Google Calendar.
I believe that capability is there. I know that something was done in my time here too, to allow, I guess I'll call the sync, but so
Okay.
it is working.
It is,
yes.
okay, that's good to know. Okay, this isn't really policy related, but I am curious, and I would love to hear at some point what schools are doing with this change. It's really interesting.
It is really interesting. All I can say from my colleagues across the county or the state that, that I hear of or attend different things is not many are touching this right now. Nobody seems to want to be first to go out there. I think there are some schools in the western part of the state that are maybe going to venture into like a 4-day week, but nobody here, particularly in our county or in our area, that is thinking of that. I think most of us are utilizing that provision for if there is inclement weather days,
Right, right.
that provision allows us not to have a snow makeup day to be day for day, as long as we have the hours calculated for. Yeah.
When the time comes that it does, people start thinking and talking about it, please, and I know you will, but just as a reminder, I got to say it, remember Eastern. And we got to all, because if somebody goes to hours, that has like a ripple effect on, the career and tech schools, so.
One thing that I will ask the board if you are interested in, I know right when I came last year, we were, I think, probably a month delayed in getting the calendar to you because of my arrival. So we'll work on that earlier than we did last year. But I know in some districts, and Mrs. Drennan comes from one, they would approve 2 years of a calendar at once so that the community would have, quite a bit of forward information. I just thought I'd throw it out there. Is that something you would like us to even draft and put together? What 25, 26, and 26, 27 could look like? You wouldn't need to approve both of them, but if you would like that, we can throw something together and at least show you what it would look like. All right, I see heads. We'll put it together and then you can decide at that point if you want to approve both or not.
I think at a bare minimum, because I get this question every single year. Do we know yet whether we're going to start before or after Labor Day? It's one of probably the most common questions that I get. So at a bare minimum, the start date, I think people would love to know in advance as they're planning their summer vacation ahead. So
And childcare,
I don't see any reason if we think we can do more ahead than that, that's great. But that one is I think that the community would love that.
Can we go back to the extra content you gave us and like how to look at that?
For policy 202?
Yeah.
Yeah, absolutely. So what I shared with the board was I was just interested in some historical information on the number of non-resident students attending the district. So in the middle where you saw the big chunk with the numbers was broken out just by school year. You can see that from the 21-22 school year to the 24-25, we have increased, I believe that's 29 students, from 123 to 152. Now, you're probably wondering, like, what's the difference between MO and a 1302? So both of those are based upon an affidavit, and I'll try to give some examples. So a 1302 student who's listed there, and those are typically our lower numbers, are students who are living with a district resident other than their parent, which means somebody lives in district and is taking responsibility, and they have to sign an affidavit that they are not receiving any financial compensation for that, and they are assuming educational and supporting this child to live with them. Their parent is not residing with them. So this would be like me living in Lehigh County, but saying that my children are living with Dr. Thomas, and Dr. Thomas signs the affidavit and takes responsibility for that, for whatever reason that the kids couldn't live with me. An MO stands for multiple occupancy affidavit, and that is actually when the whole family resides with a family that lives here in district. So the child is still with their parent, but now they are living with a district resident. So sometimes this might be multi-generations are in one home. So me and my family are now living with my parents who reside here in Upper Dublin. So we now have residency. The family who has residency has to sign the affidavit, but they're still living with their parents. So the difference is the parent with them or not? 1302s, their parent or guardian is not with them. And MO, they are living with them. In both instances, somebody who resides here in the district is signing an affidavit saying that that is what's occurring. And those are, our registrar annually sends letters out to all of those families to ensure that that is still the case for the following school year. And then, through multiple letters and receiving things back, they will return those affidavits to us. So as you can see, though, the numbers have certainly been increasing, and I couldn't tell you specifically why that may be. I know some districts, maybe have refugees that have now been coming into their districts, or again, sometimes it's multi-generational. I think the closer you may get to the city, you may see more of that as well.
And in these cases, there's not tuition that families have to pay.
I would have to look back at the policy. No, because they are here residing then in district with appropriate documentation.
And is there data about how many families are paying tuition who?
I would have to ask Mr. Leckman that. I do know that we discussed that as a result of Policy 202, we should probably have an administrative regulation with policy, I think 607 actually, which speaks to tuition, about how to collect that tuition. So I'm not aware of, even though our policy says that maybe we are charging tuition, I'm not aware of how we garner that. So we'll work on that, and I'll ask Mr. Leckman if we are collecting tuition from anybody right now.
Thank you.
Yep.
Okay, so that brings us to public participation. Okay. So that brings us to public participation. Speakers are required to state their name and their city of residence, or affirm they are a resident or a taxpayer in the district. Before addressing the board, you have 4 minutes. Seeing no one approaching the mic, I'm going to close public participation. Is there any other comments anybody would like to add?
Zainetti, just because we didn't do it during the education meeting, we should say that we received, I believe it was 3 written comments beforehand that were shared with the board and will be posted per normal practice.
Yes, thank you. And even with those comments, and correct me if I'm wrong, anyone can email us at any time. But with those particular comments, we post those, and you have to be a resident in order for that to be posted. Right? It's the same as public. I'm looking at Jeff.
I think that's correct.
Okay. So even you can, like I said, any community member can email us, or even non-community member, you can email us anytime. But in order to be part of public participation or the comments that we post, you have to live in Upper Dublin. Okay. And with that, I'm going to announce the next policy meeting is Wednesday, November 6th, 2024 at 7 p.m. or immediately following the Education Committee. And we are adjourned. Thank you.